going to be an informational meeting on, we're going to be doing our ordinance. We're going to be doing an informational meeting on the ordinance, proposed to be adopted by the town. This is only an informational meeting. Since we are out of town, out of our, out of Churubusco, we cannot adopt a meeting or adopt the ordinance. So what we're going to be doing is giving an informational one. We have the lawyer here. He's going to be answering questions, going over the ordinance. And okay, bear with me. Okay, we're going to try it. What we'll do is we're going to have people coming up to the microphone, whoever wants to talk. And we're going to give it 3 minutes for each one that comes up. We ask that people try not to repeat themselves. If somebody already asked a question, we would appreciate you just try not to repeat yourself over and over. Okay, we have a lot of people here. We're going to try to make it where as many people as we can get up and talk. Try to answer all the questions on this. Bear with us. This is our first time really doing it at this volume. We're learning as we go, just like everybody else here. Okay, I'm going to hand it over to Daniel Spitzer. He's the lawyer for town attorney in this case, and he's going to take the floor. Being that we're in the school and we have a large volume of people, I'd like you to be aware of all the exits in case of fire or emergency. There's one on each corner of the room and one in the front. So if you have to get out, follow the exit signs, get out in the parking lot.
Good evening, everyone. Thank you very much for having me here tonight. It's an honor to represent you. Let's talk about where we are and what we're doing and what the process is. Because we tonight are at the beginning of the beginning. By that I mean we're just at the start of the process. Right now, this is the state of the law in the town of Clinton. The town of Clinton does not have a zoning law or any other regulations regulating wind towers. I'm going to call them wind towers, windmills, wind energy conversion systems. You all know what I mean. If not, you can stop me and ask me. But right now, if a wind company wanted to come into town hall and say, I want a permit for a wind tower now, the town would have to give them the permit. That is the current state. There is no local law. So right now, wind towers are allowed without regulation. The town board believes that proper regulation of wind facilities is the best way to approach the proposals that have been brought forth by two companies, Noble and Verizon, who both have representatives here tonight, and I understand will join in answering questions. To the extent that I'm answering questions and the board's answering questions, they too are prepared to answer questions. These groups have agreed to wait until the town board goes forward with a law so that it's not necessary for a moratorium to be in place. But as things stand today, anybody can build a wind tower of any size at any location. What we're going to talk about is what the town wants to see in an ordinance regulating the placement of wind facilities in the town. Since the town does not have zoning, it uses what's known as its police power, its general power under state law and under the state constitution to regulate for the benefit of the health, safety, and welfare of the community. And in this case, to balance an economic venture versus the protection of the community. If you look at the beginning of the draft law, there's a list of authorizing statutes that talk about where the state has given you power to do everything from regulate noise issues to regulate setbacks. That's where you get the authority to do something. What you have in the town board right now is sort of a template of how to regulate 3 different types of facilities. only one of which is really, I think, why the room's crowded tonight, but let me just go over them. There are, of course, some big, large wind projects that these gentlemen and ladies are proposing. There are also in the law rules for small wind systems. Now, I'm not talking about the mechanical systems that we find on a lot of farms, but more and more, there are small wind energy conversion systems that rural landowners and suburban landowners in tandem with each other are using to reduce the on-site consumption of electricity. And if New York State ever moves towards net metering, in other words, where you get the same money for producing wind as you would pay to the electric company, they're going to really be valuable. And this law has a system for regulating those. It also has provisions in it for regulating what are called wind measurement towers. These are the towers, some of which have already been authorized by local communities, that measure wind strength in various areas. They're basically tests to see whether or not a commercial-sized wind project is viable in your community. The main sections of the law, though, deal with the application for review of, operation of, and removal of wind energy conversion systems on a large scale. These are the wind farms that have attracted so much notice. There are, in my opinion, three main concerns that a community has. One, that the decision to place them is properly made. Two, that once they're placed, they continue to operate within the permit requirements established and the rules established. And three, that when their life period is over, that they are removed. All of which, particularly of the last two items, are done at the expense of the applicant, not of the community. Therefore, the law has a series of rules, starting with the mandate that no one may build, operate, modify, construct, or install a wind energy conversion system in the town without first getting a permit from the board. The board would basically, if it goes forward with this ordinance, adopt a set of rules. Now, I started my discussion by saying right now it's a wide open field. Anybody can do what they want. And one of the questions people have said is, well, if you adopt this ordinance, then that opens the floodgates, right? Well, as I pointed out, the floodgates are currently open. The ordinance stops them, but the ordinance permits nothing by itself. The ordinance establishes an application procedure combined with the State Environmental Quality Review Act procedures by which private entities and public entities, if they wish to, and I actually work with a school district that's putting up a windmill at one of its facilities, can come to the town and ask permission to put a windmill in your community, or a series of windmills. So, if things went forward as the town board has laid them out, the floodgates would be closed, a process would be created, and that's what we're going to want to start getting input from you on tonight, is what that process should look like and what those rules should be. And then there would be a review process, which also has public comment and public hearing aspects. So after you have rules, you then get to talk about specifics. Like, well, yes, we said this was okay in the general rules, but here's why it's not good in this particular spot. And the town board has the authority, under the ordinance, to create a record that will allow it to say yes, yes with conditions, or no to each specific tower request. And I understand there's going to be a lot of tower requests. Now, the way this process works, once it's in place, is the applicants are required, under the State Environmental Quality Review Act, as well as the proposed ordinance, to pay for the town process of review. They do so first through an application fee. But secondly, they do so through an agreement to fund the town's experts. That means that when a wind company's expert says, this is what the noise level will be, you're not, as a town, required to rely on them. Not that that they're buying or anything, but you have a right to hire your own expert. And the way state law works is you have a right to hire an expert on their nickel. That's in the State Environmental Quality Review Act. So there will be town experts when you get to that point. If you get to that point, if the town adopts a law that says there shall be no wind towers in town, then you won't get to that point because there wouldn't be any applications. What the town board is looking at now is not, however, a ban on wind towers. It's a law that would allow wind towers that meet certain requirements. Now, if people haven't yet gotten a copy of the draft law, do they know where they can go to get one? Okay, does everybody know that? You can go to the town clerk for a draft copy of the law if you don't have it. Here's the basic outline of what the town board is looking at, and you guys all shoot me in the back with darts if I get this wrong. Basically, tonight is an informational meeting. It is not the formal public hearing on the law. Between now and the next board meeting of October 12th, the board is soliciting your comments on what a local law should look like. The goal is on October 12th to formally introduce a local law. The way local laws work in New York is they literally introduction requirement. You literally say, I hereby introduce local law. At that time, the town board will call for another public hearing. That public hearing will be held in the town of Clinton. At the same time, that local law will be sent to the county planning board for its comment. The town board would then come back, hold a public hearing. It can, at that point, if it wishes, amend the law further. In which case, if it's significantly amended, there would be another public hearing until the town board reaches a consensus on the law. Before adopting the law, the board will do an environmental review of the law and then consider its adoption. The law or any ordinance regulating those facilities has a number of components. The first is, what is in an application? I believe there's about 19 items that we listed in the draft of things that we want to see. Where are they? What are they going to look like? How big are they? How close to the property lines are they? How close to the nearest residents are they? How close are they to other uses? Where are the power lines? Where are the wetlands? What's the noise issues? All of these things are in the application. The board will review the application, and the first step is either the board or its engineer will determine is the application complete. Only when the board is satisfied that they've all gotten there, that at least all the questions have been addressed, will they start reviewing the permit request. The permit request will mostly follow the State Environmental Quality Review Act. In all likelihood, because of the number of proposals, it's expected that there will be a positive declaration of environmental significance and an environmental impact statement passed. The town board could do a negative declaration, that is an option, but based on the proposals that were received, that doesn't seem likely. It is then up to the applicant to prepare an environmental impact statement in accordance with the studies that the town board wants performed. That's where your engineer, your guy comes in, and he or she will review all the studies that they come through and tell the town board whether they should accept the environmental impact statement. Once the environmental impact statement is accepted, there will be a public comment period. And while seeker doesn't require a public hearing, your board has indicated to me they want a public hearing. They want people to get together. We may have to try to figure out how we can do that in this building if there's no place to pick it up in Clinton. It may be possible to do the local law to allow that. But that's your opportunity to start commenting on the proposals and the specific applications and to say, this is why you shouldn't allow this tower, this is why you shouldn't allow any tower, this is why you should chase these people out of town with a fire brand, or this is why you should relax them and let them do this. It is then, instead of the general comments that we're starting with tonight on the law, it is the comments on the specific application. Thereafter, the town board, at the completion of the secret process, will make a determination and a decision whether or not to issue a permit. Only then can they apply for a building permit. So you can see what the town board's main goal is to start by closing the floodgates, and then once they've closed them up, create a process by which the applications can flow and be processed. I've done a lot of talking. I hopefully have explained the process that we're going to go through and that the town is going to go through. Obviously, there's a lot of sections of the law. I've talked about the application. I want to talk a little bit after if the town board should see fit to approve this. It's also important that there be a mechanism to ensure that any facility is built continues to comply with the law. The proposed draft requires that the applicant fund independent acoustical and other testing on a regular basis to ensure that they have a right to keep their permits. And finally, you want to make sure that these facilities, for whatever reason, are no longer in use. You all go back to nuclear power, we stop using wind power, whatever the reason, that they're going to be removed and that they're not going to be permanent intrusions on the skyline. And that's fairly typical of any large facility, whether it's telecom or other facilities, to have a decommissioning plan. So the proposal in front of the board is to create a lifetime, if you will, of regulation from cradle to grave of the facilities. Should your town board decide to allow them. With that in mind, with the permission of the town board, I would ask that we open it up to the floor. I think that they want you to come up to the mic and state your name and address. Since this is an informational hearing, unlike a public hearing where you address all your comments to the town board, here feel free to make comments, but also to ask questions of myself, or the other board members, or the representatives of the companies. Everybody ready? Come on up, sir. Thank you for your time.
Edward Soltisic, and I live on the P. LeClaire Road in Churubusco. Actually wrote 5.
The law you have in front of you was drafted by me. I had some input already from some members of the board. I've had some input from the other towns in the area that I'm working with. I've had some unsolicited comments by emails and all from others in the community, but it's my product that's in front of you now. However, the town board has not really addressed some of the key items itself and really focused. They're starting to do that tonight in things such as setbacks and others. In other words, what you have in front of you is a template for what the town board wants to set up. But the drafter of what you have is me.
Also, can I ask a follow-up question?
Sure.
Did you consult with the windmill people when you wrote this?
I didn't consult with them when I wrote this. I shared it with them after I wrote this and received comments from them, some of which I accepted and some of which I rejected.
Thank you.
Okay, next. Don't be shy.
My name is Janice Padula. I own property in the middle of, right in the middle of Churubusco off Legree Road. And I have a question about the seeker process. You have stated that you're going to do a seeker for the project. Is that for the project entirely, or for each wind turbine, or for sections of the turbine? How is that seeker process going to take place?
Part of what you're talking about is a bridge that hasn't been crossed yet. What we basically have suggested to Ellenberg, and we're going to suggest to Altoona, is that to the extent these projects are sort of combined, the town should work together. We have also suggested to the companies that they should consider a joint review. Now, they're not required to do that. It's their call, and since they're paying, they have a right to do it. However, I can tell you the town and the town engineer is going to look at the impact of both, of any application that's in front of it, whether it's doing one DEIS or 2 DEISs. But we're looking to have a coordinated among the towns and the companies as much as feasible.
I'd like to thank the board for listening to the people and coming up with this action. I really appreciate it.
Hello, I'm Amy Bellion. I have a question for Mr. Spitzer. Why, when you did Malone one and you did ours, why are they so different?
I'm sorry, Amy, I'm having trouble hearing you. Can you talk into the mic? I don't have very good hearing, I apologize.
When you went and did the Malone ordinance and then you did our ordinance, why is there such a difference between the feet?
I'm not sure there is a difference.
There is a lot of difference.
Well, it's kind of interesting. I'm not quite sure what people have in terms of Malone other than a draft template. I haven't even met with the Malone Town Board yet. I'm meeting with them Friday morning. So anybody who's told you that they have the Malone ordinance or what Malone's agreed to simply has something that I attached to an email to one person that was a template and doesn't reflect the opinion
Even the
of the board.
template, why would it be such a huge difference in the feet away?
Well, what specific point are you looking for differences in?
I'm saying that the ordinance that our town has given to us and we got to look at, it is not protecting us at all.
Well,
It is not acceptable, the distance that they have put up, 500 feet from the nearest property line, 700 feet from the Route 11, 500 feet from the right-of-way of public roads, 1,000 feet from the nearest residence offsite. I'm sorry, but that is not far enough away from my home.
Okay, what do you think it should be? What do you think it should be? Tell the
3,000
board.
feet.
In terms of all of those things, or in terms of just...
Yes, because people don't realize how huge these blades are, and that you're going from the middle of this wind tower and extending it out. These wind tower blades are 250 feet, if not longer.
I think that's right. That's my understanding. Okay. So basically, what you're suggesting, ma'am, is that the board should change the setback from
Of
the
them.
tower, all the setback to 3,000 feet.
Not all of them, but they all need to be, it needs to be protecting us a lot more than what they have written down.
Okay. And obviously, what you're saying too is that the protection would be greater because you'd be further away.
Well, of course.
Okay. Is there any other specifics in the law or other comments that you want to make? Go right ahead.
Just that this was supposed to be a public meeting tonight, not a public hearing. Why did they get switched so last minute?
That's my fault. I explained that I didn't realize, and I apologize, I'm not from this part of the state. You're not in the town of Clinton now. You can only have public meetings in your hometown. And since this is in the town of Ellenburg, it can't be an official town meeting. So blame the lawyer. It's simply a matter of, to the extent that this is an informational meeting, but what that means is that this doesn't count as a public hearing on this law, even if it was adopted in the exact form that it is. What it means is that there'll be another opportunity for the public to comment. And I just didn't realize that this school wasn't in the town of Clinton.
Okay, thank you.
My name is Heather Laughlin. I live on the Campbell Road in Churubusco, and I would like to introduce Dr. Nina Pierpont to speak on behalf of some environmental concerns and health issues. Dr. Pierpont?
I'm a medical doctor. I am a PhD ecologist. I live in Malone, and I am Mrs. Laughlin's consultant on health issues. I'm here to talk about the setbacks that you proposed in the ordinance, starting with the sound decibel levels, allowing a decibel level of 50 decibels as your threshold is not in compliance with EPA standards or WHO standards. And a much better way to design the sound allowances for your law will be in compliance with the New York State DEC document on assessing and mitigating noise impacts. I'm addressing the setbacks, which are inadequate. Starting with the sound decibel threshold level of 50 decibels. That's too loud. It's not in compliance with EPA or WHO standards. It would be better if you used the New York State DEC Assessing and Mitigating Noise Impacts Statement, which is an important document in terms of mitigating noise issues for the state DEC, which I understand will be involved in the seeker process. They note that increases in sound pressure levels of under 5 decibels over ambient or background noise is unnoticed to tolerable, and above is intrusive at 5 to 10, 10 to 15 very noticeable, 15 to 20 increase objectionable, and over 20 decibels increase. And that, by the way, means 100 times louder than background. 20 decibel increase is very objectionable to intolerable. Now, background noises in quiet rural areas, such as the town of Clinton, tend to be in the 20 to 30 decibel range. So if you're talking about a 50 decibel threshold, you're talking about a very objectionable to intolerable level of noise increase. Not only is 50 decibels too loud, but measured noise levels from new wind turbine installations in other locations, for example, the Myersdale facility in Pennsylvania has documented noise levels of 70 decibels over 48 hours, averaged over 48 hours, 70 decibels. That is very loud and louder than your law would allow. On the next part of the setback rule, when you're talking about how the noise parts of the ordinance would be enforced, you come up with a very technically difficult way to measure sound. These sound problems are not going to be enforceable because of the technical difficulty and the lack of access of your citizens to the type of expertise to do this. And in general, it has been found that once installations like this are in place, no one pays any attention, and it's impossible to prove that anyone is out of compliance. So actually, the only way to protect your citizens against noise is to have proper setbacks in terms of distance. There are some other issues besides noise with the setbacks as well. To have turbines within 750 feet from Route 11 is dangerous. Route 11 runs east-west. The shadow flicker in the early morning and in the late afternoon, if you have turbines that close, will fall across the highway. The shadow, having turbines turning against the sun produces a strobe effect, which has been recognized by neurologists as capable of causing seizures in people who are prone to seizures. So you will be increasing seizure risk in anyone driving who has a seizure disorder. In addition, about 10% of the population has migraines. Most people recognize this by their susceptibility to motion sickness. People with motion sickness get dizzy and disoriented in the shadow movement patterns produced by turbines. So you don't want to have those crossing your roads and having people getting nauseated and disoriented while they're driving down Route 11 at 65 miles an hour. The other roads, the same concerns apply. To guard against noise effects at households and on properties, and noise effects, the most important one is being unable to sleep. Also, general irritation and anxiety and loss of enjoyment of life and property are noted widely around wind turbine installations because of the noise. There is good documentation in scientific literature that people are highly annoyed by the noise of wind turbines, especially groups of turbines at night, up to 1.2 to 1.5 miles away. And that should be your setback unless an easement is obtained from a person within 1.5 miles or 8,000 feet of a wind turbine facility. A person should have to agree to be within the, to have that noise, and have an agreement, an easement, in order to have a turbine built within that distance from their home. and 100 feet from wetlands is quite inadequate. Just a statement on your application process. Under D in the application process, the noise analysis done by the applicant needs to include baseline noise levels daytime and nighttime up to 8,000 feet away. Anticipated changes in these noise levels by the proposed facility needs to take into account current models of atmospheric stability with daytime and nighttime values and the presence of multiple turbines. Most acoustic modeling does not take into account these models, which are just being published at present and are very relevant to the high degree of noise transmission and annoyance near wind turbine facilities. One more comment in your standards. Under 10, attention only to rare bird and bat species is inadequate according to current standards. A regional and continental approach to wildlife abundance issues is more appropriate, and I have articles to document all of this for you. Thank you.
Permission of the board and the audience, may I just go over a couple points with you? Do you mind? Do we use your expertise for a minute? First of all, if anybody wants to you look at the DEC mitigation that I mentioned, the doctor mentioned, it's on the website, but I have a copy here, and you're more than welcome to look at it. Secondly, I think it would be good to explain what you meant by the differences in terms of the ambient and the current noise. What you're talking about, as I understand it, since I'm not an expert, I'll explain it and you tell me if I get it wrong, is that no matter what the noise is that they produce, the real key in terms of whether it would bother you is the difference between what the noise is now versus what it is afterward. And that decibel levels of more than a certain amount can produce increasing amounts of discomfort or even difficulties for the...
Obviously, absolute noise level is going to make a difference too.
Well,
but
obviously the absolute does too. But when you were
using,
talking about the ambient, the difference between the ambient, that's what you were referring to.
right, so that would give you, if say you started out at 25 decibels as your background, that would give you 30 decibels as your allowable.
Good example. Secondly, just wanted to point something out. And one other question for you that I thought would be good to explain. What specific EPA and WHO standard are you talking about?
I have the WHO document on community noise published in 2000, and the reference to the EPA I'd seen referenced in some other materials.
Okay. I spoke to a friend of mine who works for the EPA. They told me that they don't have standards that they enforce on wind towers. She's not in the windness of the noise area. She basically...
I'm talking about standards for community noise for allowing people to sleep at night, which I believe for EPA is 40 decibels.
Okay. 40 decibels in what area?
I don't know. But again, I don't have the background on this one. But the WHO one, I can hand you. And the WHO standards for nighttime noise are 30 decibels. That's indoors. But if you have open windows, it better be pretty quiet outside. And if you have any low-frequency component to the sound, it's very hard to predict how much of it comes indoors and how much below 30 decibels your threshold needs to be, because it needs to be lower if there is a low-frequency component to the sound.
Finally, I wanted to mention in terms of the noise analysis, those are all good ideas in terms of what to include. To be honest with you, my preference is to say a noise analysis, and then it's part of seeker to dictate in the scoping process or in the other process of dictating what should be in the study. If you put it in the law, I find that applicants tend to say, well, it's not in the law, so I don't have to do it. Whereas if you leave it general, then it's up to the town board and its consultants to fill in those specific details as you put together things like wildlife study plans and the other details of the specifics, as opposed to putting them in the law.
I leave that to the lawyers who are orchestrating the issue of the law and the seeker and the applicants.
Thank you.
You're welcome.
Okay, let's keep it at 3 minutes now.
My name is Arnold Holmes. I live on Route 11, and I don't know where they're getting all these noise problems. I got noise problems on Route 11. Every truck that goes in front of my house is making up 4,000 dBs, and they're worried about this little wind tunnel back in the woods. I don't know what their problem is. Thank you.
My name's Tony Bouchard. I'm a landowner from the Ryan Road.
Where do you live?
I live in Morrisonville, but I own property in the Ryan Road.
Thank you.
You're welcome. On August 16th and 17th, my wife and I took a trip down to Fenner. On August 16th and 17th, my wife and I took a trip down to Madison County in Fenner. And we took a number of sound readings at distances that are all explained in these series of photos with, I believe they're telling me, the people that made this meter, that 40 decibels or less is near silence. But I'd like to pass these around, and it explains the distance that these the meter readings were taken, and also a series of photographs of the general area showing the windmills. In addition to that, I'd like to read, if I can do it in 3 minutes, about the trip. On August 16th, 2005, my wife Jane and I traveled to Fenner, Madison County, New York. The purpose of our visit was to see for ourselves the Fenner Wind Farm. We wanted to go unannounced and not be part of a trip or group sponsored by a wind development firm. We arrived at about 11:20, and at the time none of the wind towers were operating due to a lack of wind. We were on Mile Strip Road between two units. With our vehicle parked on the east side of the road, I took a distance reading with a Bushnell rangefinder. The unit to the east was 143 yards to the base, and the one to the west 240 yards. Since the units were not rotating, we took a sound reading with an X-Tech sound level meter inside the vehicle, and it indicated low or less than 40 decibels, which is silence. At about 11:40, the unit to the west started to rotate, and between 11:53 and 11:54 made 10 revolutions. At this time, we recorded dB readings on the meter between low and 54.4 decibels, and took pictures of the meter. The readings were taken at distances of 143 and 204 yards. We then moved to a distance of approximately 100 feet from the unit to the west. During this time, the east unit had slowed to about 5 RPMs. We again took readings with the dB meter and photographed them, and the readings were from low to 48.9 decibels. Our last reading was taken with the meter on the base stairs of the tower and recorded 56.3 decibels. Before leaving, the tractor trailer passed our vehicle and recorded a 75.6 dB rating. The noise produced from the unit sounded like a clothes dryer with a pair of sneakers inside, but very muffled at this distance. About 12:30, we drove a short distance and stopped at Stone Brothers greenhouse. We visited with Tom Stone Sr. and 2 other gentlemen about the units on his property and history of the project. Mr. Stone indicated that approximately 95% of the people were in favor of the project. Opponents were few, but very vocal and set against it. Mr. Stone mentioned that the town received $150,000 annually from CHI Energy, the owners. A customer in Mr. Stone's store mentioned his main complaint was visitors getting off the New York State Thruway, stopping at McDonald's and littering the side roads while viewing the wind farm. Other than that, he felt the wind farm was good for the area, and he lived about half a mile from the tower. We took a few photos and thanked Mr. Stone and the others. Next, we traveled about 3/8 of a mile north and visited with an elderly man in his yard. He appeared to be about 7 years old and had lived in the area many years. His home was about a half mile to the nearest tower. He said he didn't have a problem with them. In fact, he said he liked the project and how they lowered his taxes, and he hoped they would build more. We next wanted to find the substation and talk to more people. We drove east and located the access road to the substation, but it was posted, so we did not enter. We drove south and saw a man in their house working on his truck. His name was Joe Griffin. Joe had 2 units on their property and had worked with a contractor during construction. Joe gave us a lot of positive information on the project and had a very extensive photo album of the construction period. Joe told us the service building for the towers was just up the road, so we decided to have a look. The building was about 40 by 60, 1-story, appeared to have spare parts and tools inside. We met a worker who was employed by General Electric that did service and maintenance work on the units. He indicated the units were fairly trouble-free. One thing we noticed about this area was how close some homes were to the towers. Some of the homes were quite large and did not appear very old. All were occupied. The area of the project was on a ridge south of Route 5 and had a nice view. After, we took a chance and drove up the road to the substation. It did not make any noise that we could hear, and we took photos. We next drove south to the town of Fenner offices, but only one worker was there since the offices are only open until noon on Tuesdays. Yep. The rest of it is basically about the Loudville project and what we found over there, which was pretty much the same, which is under construction. We didn't find a lot of opposition to it. It's okay, they can pass these around if anybody's interested.
My name is Aaron Phillip. I own property on State Route 189. Recently moved there. Everyone here has their own agenda. He wants to make money. They want to make money. I would like to keep the money that I already have invested in my home. Nowhere can I find anyone saying my house is going to increase in value with these things that are going to noise, potential health values and everything else. Nobody can explain that. Why did I say by a school that has to be so much farther away than by a person's house? Explain that to me. Why is it not good for me? The water sounds like he's an advocate for these wind turbines. That's all I have to say.
But do you think that's other than the one setback of 2,500 feet, do you think there's any other changes that should be in there?
I said what I said. That's all I have to say.
I asked him again, other than changing the setback to the same as the school.
I don't want to change the setbacks. Excuse me. I did not want to change setbacks. I am totally against this project. What I says, the question I asked, why is it good for me to be so close to them and the school not further away? That's what I asked. Not that I'm for it or I want the larger setback. I don't want it at all. I don't want to hear it. I don't want to see it. My whole life savings is in my house. Had I known that this here cockamamie thing was going to do, I would not move like I said the last meeting. That's all I have to say.
My name is Dinah Miller. I live at 1311. My name is Dinah Miller. I live at 1311 Clinton Mills Road, Churubusco. On August 26th, my husband and I traveled to Madison County and observed the wind turbines. We drove around the area, stopping several times, taking pictures and listening to the sound of the turbines make. The size of the turbines was astonishing. The sounds given off by these structures were very noticeable and was in no way pleasant. My husband compared the sound to the sound which a train would make if it was constantly rolling by. The setbacks that are proposed in the ordinance are unacceptable in its entirety. We believe many people in the community will be driven from their homes by the noise that these turbines will produce if they are placed as proposed in the ordinance. We have heard rumors going around town that the town may get new highway trucks and fire trucks from the wind companies, free electricity, free internet service, a lot more things. Today I spoke with the Town of Fenner Town Supervisor Russell Carey, where they have 20 GE 1.5 megawatt turbines. I have asked him if his town received any new highway trucks or fire trucks from the wind energy corporations. His reply was, no. These are bribes blowing in the wind. We believe these turbines should not be placed in the town of Clinton.
My name is Michael Bland. I live on the Ryan Road, Churubusco. There we go. First question I would like to ask Mr. Spitzer is, for liability on this, if it comes into a lawsuit, I know the wind tower people are going to be responsible, but is the landowner going to be responsible as far as liability for health problems or anything else created?
I can't speak to the contractual relationships between the landowner and the wind companies in terms of what these companies have, and I would ask them to. Generally, a lease like that says to the extent the landowner has liability, they're responsible for it. So if they want to answer, they're certainly welcome to. But that's really a relationship question between the landowner. If you have a legitimate private nuisance action against the landowner and a wind company, whether or not the wind company indemnifies the landowner is really a matter of their relationship, it's not a matter of town law.
Okay, one other thing for Mr. Beauchard is he stands to make a lot of money from this deal here, you know, with the land and probably subcontracting and everything else. And if he thinks really that these towers are so really nice to look at, he should sell his place in Morrisonville and build his house on the Ryan Road.
Yeah.
My name's Lorelei Tolman, and I got property on the county line in Churubusco. It's my understanding that the windmills are going to be in the country, not in town. So I don't know why they have to worry about it. If it's out in the country, they have to track that coast.
If either of the companies want to answer about where they're proposing them, that's up to you. There's no applications in front of the town. So the town can't answer, but if the wind companies want to discuss it, it's up to you.
John, you're not...
Let me repeat my answer, ma'am. Ma'am, let me just repeat my answer because I didn't hear it. What I said was the town doesn't have any applications currently. We all have seen the ISO website, but if the two applicants or proposed applicants want to answer the question as to where they're proposing to put the towers, they certainly are welcome to do so.
Okay, well, in confirmation, it's not Noel's intention. It is not Noel's intention to put a wind farm adjacent to the hamlet of Churubusco.
What's the definition of next grade? How close?
Can you come up here to the microphone so we can all hear you? Whoever yelled out that question, can you come up? I don't think everybody, I didn't hear you, I'm sorry.
Why is the wind companies refusing to show maps to the citizens of the town of Clinton where these turbines are going? On September 13th, I went to Noble. Zilka was not available, and I asked to see the maps, and they said no.
I'm not aware of any law that there's all out the answer.
Okay. Hello? Okay, if I don't start answering some of these questions now, like when I do get an opportunity to answer, I'll be going on half the evening. I'd like to deal with that question first. We have a very good idea of where we will be locating windmills in the town of Clinton. However, as I pointed out at the meeting a couple of months ago in Clinton, it is important for us not to declare what the shape and size and location of our wind plant will be until we have finished doing our environmental study. It is quite probable that what we have as a good indication of what the wind farm will look like now will modify after we've done the fall wetlands delineation and the fall studies of the environment. it is not a good thing for us to tell landowners and people living in the area that, you know, this is the wind farm, and then we have to go back and say, oh, by the way, that's not what we meant, this is the wind farm. So we have explained to all the landowners who have asked us and all the people living in the area why we will not declare what the wind farm will be until we can say with certainty that that is what is going to go into the application. To do otherwise is unfair to the landowners, to create expectation, and then to have to dash that expectation. On the matter of bribes, I want to deal with this now. It is inappropriate to come to a public meeting and to discuss making bribes to towns or town managers. I hope everybody in this room understands that, you know, that bribery is not what this is about. We make a pilot payment or a host community agreement payment to town management, and they are free to do with that what they will. On the issue of indemnification of landowners, a question was asked about the liability that might pass to a landowner in the event that there was an action against the wind company or the landowner. The agreements that we make with the landowner include a couple of clauses to cover it. In the first instance, we insure the landowner, we name the landowner and, you know, his heirs on our insurance policy, and we provide him with a copy of that insurance policy. We further provide an indemnification to the landowner in a form that permits the landowner to take any action that is brought against him to us, and we must pay for the defence and then pay anything that is necessary on foot of any legal action or settlement. The issue of setbacks, the purpose of setbacks is, there are two reasons for setbacks. One is safety, and the other is mitigation of impacts of the wind farm. We really need to have a fuller explanation of you know, the rationale for the setbacks that we have seen in this ordinance, which incidentally are the most restrictive setbacks that I have seen in the state of New York, and I think my friends on the other table would concur with that. The setbacks that have been proposed here are more restrictive than anything that has been put in any ordinance to date in the state of New York. Setbacks achieve two things. The first is a safety consideration in the event that a turbine were to collapse or fall over. The setback from a road or a building obviously has to be such that the turbine or the turbine equipment or blade would not fall on top of anything. The second consideration is impact on residences or people living in the area, and the primary consideration is noise. It's not possible at a meeting such as this to show you modelling that goes into understanding what the noise is going to be at any particular point on the entire footprint of a wind farm. But we do have modelling that we'd be happy to show, I guess, smaller groups of people who are interested in this, to demonstrate that every single residence in our wind farm, I'm quite sure I'm talking about Silka as well, will not experience any noise in excess of 50 decibels. And the modelling is based on the assumption that the ambient is zero, and that there is no tree cover, and that there is no interference in the line of sound from the source, the windmill or the array of windmills, to the residence. To explain this requires a visual presentation, and it requires a certain amount of explanation. We're happy to do that as a separate matter. I think I've said enough right now. I can address more questions later on if people want me to.
Patrick Doyle from Horizon Wind Energy. We were formerly called Silka. As a general matter, I agree with the comments made by Mr. Quirk here. Just a comment on the noise measurements. What we would plan on doing is having about 5 noise monitors, placing them at the houses of neighbours, so that the noise can be measured, and we would measure the ambient noise. We'd measure the ambient noise at no wind speed, at quarter wind speed, at half wind speed, at three-quarter wind speed, and at full wind speed. So we would be able to tell you what the noise is here when the wind turbines are not running, and then as part of our secret analysis we would also superimpose on that the noise generated by the wind turbines. And so as part of the process that we would go through, you would see for all wind speeds, all octave bands, all locations, what the impact of these wind turbines would be. So just so folks know, we will go through the measurements, and we will show you in public forum what the outcome is. And so you will all know what the possible impacts of these wind turbines, the wind turbines are. The one thing I would say is it is a lot wider than the trucks going up the main street here. So anyway, just to add to what John was saying.
I have one comment regarding
Okay, here
She asked his name, he said his name is John. John who?
What's your name?
My name is John Burke.
John Burke. Can you verify this is a copy of the Noble contract? Okay. Meaning it's not signed by the landowner?
Well, no. For example, section 3 appears to be missing. It goes from section 2.11. I see, we're down here, I'll beg your pardon, okay? I believe it.
So you believe this is a contract?
I think so, yeah.
I just want to make 2 points that he reiterated. One, on page 7, it states, in response to your question and his answer, developers, shareholders, directors, officers, partners, and members shall not have any personal liability for any damages arising out of or in connection with this agreement. And hopefully my last statement. 2.1.4, an exclusive easement to permit wind power facilities located on the property, on adjacent property or elsewhere to affect the property, including without limitation, visual and non-visual and auditory and non-auditory effects. Thank you.
No.
You're being a wee bit selective there. The clause you're referring to goes on to say that the liability rests with the company, not the individual directors of the company. The easement also says, I'll just find it here now in a minute. Easement also says, insurance. Developer agrees to maintain liability insurance covering its operations on the property. Owner shall be named as an additional insured at all times that developer is engaged in construction or operation of the wind power facilities on the property. Section 4.5, indemnification. Developer shall indemnify owner against any loss or liability of owner that results from any third-party claim for personal injury or property damage resulting from developer's negligent actions or inactions in the conduct of the operations hereon. That's a full indemnification. This clause that this lady was referring to talks about where the liability rests, that it rests with the company and not with the individuals in the company. It's a different thing. When you read a clause, you have to read the whole clause.
I need to make a comment on the forum tonight. This is set up a little bit unfairly because you guys all have questions. We all have answers. My name is Ann Britton. I'm from Brandon. I represent and am a member of a group of people in Churubusco, as well as Ellenburg and Malone and wherever else you want to be. Everybody here has a positive rebuttal on wind power, okay? Where's the rest of the information? We're not sitting up here. We are here, and we do expect to be able to offer any information and any rebuttals to the false claims that are made in this room tonight. Thank you.
My name is Glenn Bell. and I live in Plattsburgh, but I own 430 acres of land here. I've owned it for 13 years, paid taxes and high ones, and they keep going up. I was pretty skeptic of the option to lease, so I brought my paperwork to a lawyer, John Niles. He read through it. He thought it was a good option. And I think that it would help the town, help everybody else out. It's going to help me out, that's for sure. So, thank you very much.
Can everyone hear me? My name is Elizabeth Weitzman. I live on Route 189. I actually live here. And I'm hearing a lot of people talk. We've had some experts that have seen Dr. Pierpont, and we have the experts from Noble. And it's very interesting, and I'm not an expert in noise. I don't understand what ambient wind noise, and please don't try to explain it to me. What I do understand is at one point in the capacity of my job, part of my job involved being in a booth listening to trucks, which people have mentioned the sound of trucks, the noise level of trucks. And what we did know is the reason we were only put in that booth for an hour at a time is to listen to the constant sound of trucks made people very upset, very anxious, very tired, very fatigued, very stressed. I understand that trucks drive by. I don't know the noise level of Route 11 since I don't live there. I do live on Route 189, and I understand the noise level of trucks on 189. Our house is quite close to the road. But I do know that the constant sound of something like that causes a lot of problems. I'm not an expert. I know what I've experienced, and I know what other people have experienced.
My name is Chad Garrow. I live on the Patnode Road. I built here about 13, 14 years ago. My wife and I moved up from down south in New York. And we chose this town for its quietness and pristine views. I do not believe the towers that are being proposed will enhance these views, nor will it keep it quiet as we would like it to stay. The towers, the proposed variances and setbacks are totally unacceptable, and as a taxpayer, I do live here, and I will have to tolerate the noises, the inconveniences of the construction, the tax exemptness of the company unless the town chooses to have them pay taxes, as they choose to have me pay taxes for what I own and what I do. I would like to see these towers in an unpopulated area. They say this is an unpopulated area, but I'm here as a human being. I'm standing here, I do live here. It makes it populated because there's a few other people here that are living here also, and it makes it populated. So I would like to see them move elsewhere where there is no population and they will not be interfering with people's lives and their daily routine. And I do agree with Dr. Piermont's entire statements that, as I wrote in an article in the past in the paper, they have to consider the citizens of this town, and they have to keep it in mind that we are going to live here 12 months of the year, and we just don't own land here and live somewhere else. And they have to also consider any energy that's produced by the turbines, say electromagnetic resonance, and they have to make sure that those do not affect anybody's heart monitoring units that may help them stay alive, or any ambulances that may be going through the area, or any medical facilities that are trying to save somebody's lives, like the little medical facility in Chateauguay. They can't have them anywhere near places like that to interfere with the health care of the citizens. The most important thing is that the town board needs to stay with an unbiased opinion until this is over with. and not have a pro attitude from the get, as I have seen projected by some. And I believe that, like I said, they should be in unpopulated areas where they don't interfere with people's lives.
My name is Dick Nikos. My wife and I own and operate Dick's Country Store in Churubusco, New York, and I'm here to ask the town board to go ahead and proceed with forming the ordinance for the following reasons. I think that the storms of the last couple of weeks are proof to just about everybody in this room that our energy system in the United States is very fragile. And although we're only dealing with our small town of Clinton, that it could be a step in the right direction to serve the energy needs of the future. In the middle of this summer, New York State hit a record high for electricity consumption, over 1,000 megawatts over any record that was set before. So we need the power. There's no doubt about that. How we're going to get it, there's many ways that it can be done. Wind power is one, and I'm particularly in favor of it for the following reasons. Environmentally, it's very, very safe. There's no pollution from wind towers. And the fuel to operate the tower, once the tower is in place, is free. The wind blows every day. And it blows real hard in Churubusco almost any given day. So we have a good source of fuel, which is not going to cost us a penny once the tower is in operation. Once these towers are in operation on a little larger scale, they will effectively lower the wholesale cost of electricity, which hopefully we'll see some benefit from, or at least it will keep the cost of electricity from going up. So we have the wind. It's environmentally very desirable. The state government, the federal government, they are all in favor of this type of renewable energy. They're all pushing for it because obviously they've studied it, and I'm assuming our state governments have faith in their studies. They feel that this is a good option for good, clean energy to address the needs of the future. On a more local level, what we would be saying no to is a fair amount of income for our town, which would effectively either stop our taxes from going up or maybe lower them a bit. I talked to some of the people in town of Fenner, and they have actually dropped their taxes because of the income revenues from wind towers. Land values, as far as I can find out after making phone calls to agents in various areas of New York State where they have wind towers, have not been hurt by the addition of wind towers into the landscape of the various communities that have them. In fact, one lady told me that the prices of land have gone up in her area, and then another fellow told me that people that are moving into the area want to be in view of the towers. So I don't think that that's a concern for everybody. Obviously, we're not going to have a plan that's going to please everybody in this room, but we have to work for the majority and for the good of our town. And I think that going ahead with the wind towers would do just that. Will help to keep our tax base low. We'll be generating good, clean energy, which the world needs, everybody needs. Other countries of the world, Denmark gets over 20% of its energy from wind production. And several other countries in Europe have a large-scale wind farms and get a large percentage of their electricity from wind production. At present in the United States, we don't get a lot from wind production because we don't have many towers yet. But this is just one of many projects that will be carried on, hopefully throughout the state and throughout the country. I just spoke with a gentleman I know from the state of California. He says it's a very common thing. And also his wife from the state of Iowa. She said they're very common in Iowa, and everybody is pleased with the results that they're getting from wind towers. Some people object to the appearance, but other people say they think they're real nice and they're real pretty. One person said to me, "That's a damn nice machine." That was his exact words. So, although we can't please everybody, I think we have to try to address what's good for the majority of the people, and that's why we're here. We're trying to figure this out. My personal opinion is I think this will be a good benefit to our community. They'll bring in some revenue. We've also heard I've heard some claims that these companies don't pay after they get set up. Well, it's obviously the ordinance is going to be put in place so that they will be bound by law, by the ordinance, to make their payments. And I think these companies are full aware of that, or they wouldn't be here. They don't come here expecting not to pay their way. So basically, I would hope that you, the town board, would go ahead with the ordinance, and I think we need the ordinance just to make sure that the companies do what they say they're going to do and do in a timely manner, and in a way that's going to benefit our community, it's going to benefit our country, our environment, and hopefully make us a better place to live. Thank you.
I have a fact to present, okay, Mr. Dekas. Okay. Well, it goes with...
I just want to ask people, Mr. Dekas made some interesting comments, and I'd like to know who's getting what? Who's going to get the power? Who's going to get this power? And I'm not going to get the power, I'm not going to get a tax cut, I'm not going to get anything. The only thing that I might get is a devalued house. That's my question. So who's getting what? All the people in favor don't seem to be living here.
The power from this project is going to New York Power Authority. It's not even going to NYSEG, okay? That's a fact. Just because a pilot is written into law or these companies are taxed, there is proof they don't pay them. Florida Light and Power is the largest wind farm company in the United States, and the town, ironically, the town of Clinton, Pennsylvania, is fighting them right now because they owe over $1 million in taxes on their 2 wind farms from 2004 to 2005 that they refused to pay.
As far as the payment of taxes, and if just the Noble project proceeds, then estimates on the figures there, the town of Clinton would benefit, just the town alone would gain roughly $200,000 into our budget, which could either buy us more equipment or it could lower our taxes. So that money, if you've got land in the town of Clinton, your taxes could go down. Okay, the power does get sold to the New York State Power Authority. It goes into the independent systems operations where it is redistributed to whatever part of the state needs it. That's where the power goes. Hopefully, with more wind turbines, the wholesale costs will go down, and our energy costs will either stay the same or hopefully go down. If we had a big enough company that we could buy power directly from Mobile or Horizon, we could do like Ross's Point does. They have a very low rate because they have their own power company, but we're not set up to do that. If we could do that, we could save a lot of money.
If we can have on a second, why don't we address the issue of economics for a moment and the taxes and all, and then I think this gentleman wanted to also answer an earlier question that was posed about the energy. But in terms of this draft that's in front of you, the recommendation is that the New York State exemption on real property taxes for these facilities, that the town opt out of it. In other words, to the extent that New York State has granted these facilities an exemption, the draft law that's in front of the board recommends that the top town opt out of that agreement. Therefore, the companies would either have to pay taxes on the rolls or enter into some type of pilot agreement with either the IDA or the town. What those particular benefits are, in my opinion at this time, is absolutely speculative. You have no application, you don't know how many towers they're proposing, you don't know what the IDA is going to say. At this point, the town draft maximizes the town's ability to gain tax dollars by opting out of the tax exemption. Beyond that, I would respectfully suggest that it's speculative, particularly since no matter how much money is raised, whether it actually reduces taxes is really a function of what your town board does with that particular budget. Same with the schools and the fire districts in the county. So, and I think if anybody said more than that in taxes, certainly the two companies can talk about what their proposals are. But that's the only thing that's in this draft is no state tax exemption. The question about who gets the energy?
Thank you. Yes, hi, I'm Mark Lyons from Noble Environmental Power. There were a couple of questions. First of all, where does the power go? I think Dick DeCosta did a good job explaining that. Basically, if the town of Clinton had its own electric system, we would sell the power directly to Clinton, but unfortunately it does not. So we're selling the power into the regional grid, and it will serve customers starting from very close to here throughout the state of New York. but because we will help reduce wholesale power costs, that will have a positive impact on everybody's rates. Property values, as the question was raised, there have been a number of documented studies on the impact of wind farms or wind parks on property values, and the findings are that they do not, the existence of wind parks does not decrease property values. I've read those studies. We have them available on our website, or I believe they're in the town hall for you to read. They've studied all the major wind energy projects in the country. I've made a number of calls of my own. I'm curious to know myself. So I called the town assessor in Searsburg, Vermont. She said, you know, on the contrary, property values have gone up considerably since the wind projects have gone in. So in any case, the one thing I can tell you for sure is that our wind project would pay a significant amount of pilot payments. The issue of, and we're talking on the order of $500,000 or $600,000 a year that would go to the county, the schools, and the town. So that's a substantial amount of power of taxes that it's up to your town officials and you what you do with that money. But it's hard to imagine that that won't have a positive impact on the economic picture for Clinton. The issue of Florida Power and Light dispute on their property taxes came up. This is one of the benefits of a pilot agreement. When you have a legally binding contract that says in writing how much you're going to pay the town and the county and the schools every year, these tax disputes don't come up. So that's one of the benefits of a pilot agreement. It's one of the reasons why that we're proposing to enter into a pilot agreement. I think that covers the questions so far. Thank you.
My name is Bruce Brewster. I'm very interested in the tax impact of this project. And Ann Britton said that in Clinton, PA, the town was not able to collect the taxes from the wind farm company. If I don't pay my taxes, I'm subject to having all of my property confiscated. Does this ordinance or does the town have the same right to collect a pilot payment as they have in collecting my taxes?
No, pilot payments are different than taxes. Taxes that are not paid to towns are actually collected by the county through the tax collection procedure. Pilots represent contractual obligations and require a lawsuit to seize the assets or otherwise get a judgment against the company.
The contractual agreement is not between the town and the wind farm, it's between some other organization and the wind farm. Can the town, for instance, put in a clause that causes it to be such as taxes or be as enforceable as taxes are?
Okay, let me break it down into a couple of parts. First, a pilot agreement could be with the IDA or it could be with the town. And as the gentleman mentioned, it also could be a host community agreement. To the extent that the agreement is with the IDA, the town is what's known as a third-party beneficiary and has specific rights under state law to collect and go against the company for collection, including interest and attorney fees. That's written into the state statutes. So it's different than taxes, but it's also governed by state law in terms of IDA pilots. In terms of a town pilot or a town host community agreement, yes, such a clause as that could be written into the agreement that the whatever assets that you negotiated or other collection procedure could be into an agreement between the town and the individual applicant.
Are you familiar with what may have gone wrong in Clinton, PA, and can that be overcome by the town?
I have no information about Clinton, PA, to be honest with you, sir. I'd be more than happy to look at it if somebody presents it. That really, Pennsylvania law doesn't apply here. I'm much more interested in New York law and the ability. Well, actually, it's not, sir. And I'm much more. And my law firm represents the Clinton County IDA, so we have a pretty good idea of how IDAs work, and we know how the laws work for collecting from IDA pilots. As to whether or not you can collect from them, if it's a town pilot or it's a town agreement, that's something that would be in front of the group and the whole. And since everybody could comment on it if they didn't feel there was procedures. But what happens in one state is not necessarily valid. What's important to me as a drafter of the laws in terms of protecting the towns is that for each obligation that a company enters into, there is some form of security beyond the mere goodwill of the name of a single asset entity that owns it, whether it's a decommissioning fund or whether it's another procedure. To the extent that the state statutes control taxes and pilots, that's part of that. To the extent of contractual arrangements, for example, you could have an agreement that says if you don't pay your pilots, the town's allowed to go against the decommissioning fund to recover that money. That would be one potential clause in a private agreement. Obviously, I'm not speaking for them, and I'm not speaking for the board. My job is simply process, not substance. But that's one way that you can accomplish that. But in terms of what happened in another state, in terms of unpaid pilots, it could be bankruptcy, where if it's taxes or pilots, if it's bankruptcy, there's no money to pay. It could be any of other reasons. I'm not familiar with that state's laws. New York has a very strong law to protect, in the case of IDA pilots, in terms of procedure. But again, if you had a bankrupt entity, then I think it's where you look in the law and in terms of some obligations, and then you look at the agreements in terms of other obligations to talk about how you're going to back those payments up if they go bankrupt. Obviously, you have the right to seize the assets and sell them. These turbines do have a significant value. But it's a perfectly legitimate question as it relates to if it ends up being a host agreement or a pilot agreement, security to backing up their promises. One of the things, by the way, that's often on host agreements is if one side or the other doesn't comply, the obligations stop. For example, if one side doesn't, if you don't pay an IDA pilot, one of the IDA's remedies is to put the property back on the tax rolls, which significantly increases the potential. Similarly, in terms of if a town doesn't comply with certain things, the host community payments can stop under certain circumstances.
So we're not likely to see the same problem that's happened elsewhere?
You know, I don't know what that problem was, so I can't comment on it. But the one situation that I think that you need to think about is bankruptcy and how you're going to protect in case of bankruptcy. This is one of the things that I don't know if it was this town or we've talked about in terms of what happens in terms of the obligations of the decommissioning fund and why it's important, for example, in the way this is set up, the decommissioning fund actually belongs to the town and to the insurance company that sets it up with a surety. It's not an asset of the bankruptcy court. And every town in the state that I've seen has that same provision. So, for example, if these folks went bankrupt, that doesn't affect the decommissioning fund. The creditors couldn't grab that as a way of paying it off. So that's one example of security. I think it's a kind of issue that if the town ends up with a pilot or a host community agreement, those are certainly some issues that get looked at that time. Okay, you made a promise, how are you going to back it up? The best ordinances, and everyone I've worked with, and I've represented a bunch of municipalities, and I also represent lots of developers, the best ordinances basically take a, I like you, but that doesn't mean I trust you approach. Thank you. Excuse me, what is IDA? I'm sorry, it's the Industrial Development Agency, and I have no idea whether these folks are planning on making an application to the Clinton County IDA or not.
What do we ask?
You certainly can ask them anything you want.
Another question is, they're not a municipality, or they could be a municipality. Can they claim eminent domain on property?
You're talking about the wind companies?
Yes.
Unless the wind companies registered as what's known as a transportation company, I do not believe that they have eminent domain, even if they are considered public utility for land use reasons. Transportation companies started out, of course, as the old railroad, which had eminent domain, but they also include pipelines, electric companies, anybody who basically, it's New York's classification for what we call utilities. Although these are not registered necessarily as utilities, and the courts in similar situations have considered some similar type activities as public utilities, it's not clear whether these facilities would be. What is clear is that I know of no reason why these companies would have eminent domain powers. They are private companies, they are not public utilities regulated or licensed by the Public Service Commission, and I know of no authority that they would have for eminent domain. Now let me give you an example of what that means. Let's say that they want a noise easement from you because they're too close to your property line. If they had eminent domain power, they could in effect take your property to put it in. That's what an electric company could do if it wants to put a line through. These companies, and you gentlemen, correct me if you disagree, these companies don't have that power.
We do not. Absolutely. Well, it wasn't, I read in the paper a while ago that there was a law passed for like a town itself or a city can claim eminent domain on property for private,
what you're talking
private corporations, like they tore down people's houses for malls.
Yeah, what you're talking about is a decision that the Supreme Court did this year. It actually did not change the law, but a lot of people didn't realize just how strong eminent domain was. The particular situation in that case was a town in Connecticut took people's private homes in order to tear them down for a hotel or to support a new fight and drug complex, in other words, for economic development. And the question was, could that be done? The courts have long recognized the right of communities to take private property for things that are not necessarily public uses in terms of like water, sewer, roads. And in a particular area, it's always been found that they can take it for blight. You have a slum. Communities have long been allowed to clear out slums. But this was a case where you had a nice neighborhood. And there had been a very famous case in Michigan called Pole Town, which was a neighborhood in Detroit that was taken by the city, given to Chrysler for a new plant. And it was not a blighted area, it was actually a very healthy, integrated community. The courts upheld that. Michigan Supreme Court upheld that, and the land was taken. And I think about 500 Michigan Supreme Court last year reversed itself on Pole Town. And a lot of courts have been looking at this issue again of just how broad is the eminent domain power. And the courts have specifically said that communities can take land for economic development purposes, even if that land is already put to good use, if the town can show that this is a better use. Not surprisingly, both in the Congress and the state legislatures, that Supreme Court decision has really upset a lot of people, and I suspect that we haven't heard the last word. But I should tell you that that's actually been the law in New York forever. There actually are examples where that previously happened in New York.
So basically this could happen. If you got one piece of property holding up two companies, the town could say this is for the better of the town and claim eminent domain on that piece of property.
If it can prove to the court that that's better use for the community, the answer to that is yes. And generally the courts have deferred to the communities. There was a case out of a part of the state that I live in where they literally took a piece of land from Quality Markets and gave it to Tops Markets. Because Quality had bought a piece of land and prevent Tops from buying. And the city went in and bought the land in order to complete the deal. And the court said since the town had determined that that favored jobs and created jobs, that's the end of our review. Now, I would not be surprised, there's a number of bills in the current state legislature that limited that power. These gentlemen certainly don't have that power. I would be shocked if these folks ever considered it in terms of wind or any other utility. But if you wanted to say to them, I think you should put in your law that you promise not to use eminent domain on behalf of any wind applicant, I certainly have no problem recommending that because I don't think a town would do that anyway.
Okay, one more question. In your ordinance, I didn't see anything on substations for distance from footage-wise.
There is no specific setback for electric. They are required to show all aspects of the project, including substations, and there is required to be part of the environmental review, any substations. However, you're correct, the ordinance doesn't suggest any particular setbacks, and if you want to board. And let me point out something too. I said earlier that this was the beginning. Don't hesitate to write letters to the board or call them up in lobby and say, hey, I'd like to see you change this. And if you wanted to recommend a setback for a substation, or that it has to be walled in or something like that, within the requirements that, generally those are set up, those are generally, even though they're part of the environmental review, they're usually built by the utility. And utilities are very, really, NYSEG basically. And they have a very different set of rules that they have to follow. Are you planning on building your own substation or is NYSEG doing it for you? Okay, are you going to own it or is NYSEG? It's yet to be determined. And same on your side. So these are legitimate questions. If you want to see the board put in some rules about substations, no reason that the board can't consider your suggestions.
I just got one thing to say to the community. Really, we're attacking the wrong people here with Verizon, is it, and Noble. We should be attacking the ordinance, which is such a marshmallow ordinance what they have. I mean, that the board is who should be attacking.
I live in the town of Churubusco on the Campbell Road. I just want to reference back to when Amy was up and she required and talked about these setbacks and measurements. I want to ask the board members, did you guys vote on this along with our town supervisor, or did the lawyer come up with these measurements? I'm asking the board members.
Board members to answer.
They were provided to me by Mr.
I'm asking the board members.
Exactly what he said. We all got together on that and we gave him the measurements.
You gave him the measurements?
Well, the 1,000 feet, you know, we discussed it. We had threw out some numbers at first and then we discussed it and we got back to reality. And what we ended up doing was we seen the papers from the different setbacks from all the other towns, and we took the high end of it.
The high end? Is that like?
As in basically, I think one other town here we had was 1,100 feet from a non-participant. And we, you know, some were 600 feet, some were 100 feet, some were 750 feet. Yeah, I can read it right here. Yeah, we can give you a list on it. These are all the projects was in New York, and we took, you know, we went with the highest ones. We went far beyond what we had to do on it. We thought we were going really conservative on this and taking it far back from what we could have put it.
Well, I'd like to know if you guys actually voted on it. I mean, you still didn't say you voted on this.
We didn't vote on this because we never did it at a public hearing.
So when did you guys talk about the footage?
We talked to the lawyer.
So you discussed it in front of the lawyer, not amongst the town board and the town supervisor prior to talking to your lawyer?
No, we talked with the lawyer about it.
So before, how long ago was that, would you say?
This is silly. You have a point.
Yes, I got a point. I'm not talking to you, mister. I'm talking to my town board and my town supervisor. I was up here speaking. I didn't interrupt you, so please don't interrupt me.
Sir, you have a point.
I want to know who voted on these measurements.
I put them in there at the request.
Okay, so you put them in at the request of our town board.
Yes.
So may I ask the town board, are you happy with 500 feet?
That's why we're here.
Right, but I haven't heard any of this come up tonight. Amy had the first question on it, and it seemed like it got brushed on at the table, and we started in on this other stuff. I want to know right here on number 5. It says 2,500 feet from the property line of any school or church. May I ask every one of the board members, how many feet do you live away from the town church?
Yeah.
Can you answer that, Mr. 1,500, 2,000? Do you agree? About 1,500, 2,000? Calvin, about 1,500, 2,000? So basically, the whole board members live past this 2,500 feet of property line that you guys put in the proposal. So why didn't you, as a town board and a town supervisor, just take a little trip around our community and stop in at local people's houses and say, what would you think about 500 feet? They would probably say, well, your 1,200 or your 2,500 feet that you got from your property line, maybe some of the people here would probably agree with that a little bit. Well, I'm here.
We put out something in the ordinance.
I mean, when Amy requested 300 or 3,000 feet, half the room chuckled, and you know everybody here looked at each other and said, "Oh, yeah." Well, I live out in the country, and I don't think 500 feet from my property line is enough.
What do you think it should be?
I think it should be 8,000 feet or another state. One more question. shortage. I wanted to know where these numbers come from, and now I found out where they come from.
You're more interested in finding out what's going to be in the ordinance after October 12th, giving them your opinion and telling them why? Don't you want to tell them what you think should be in the ordinance when it's
That's
introduced?
what we're here tonight for. I thought that's
so-
what this meeting was going to be about, but no, we come in here with 500 feet, 1,000 feet.
Well, obviously you haven't been paying attention, because I certainly heard a lot of different opinions, including the I haven't gotten the impression that there's a heck of a lot of people here that don't want wind towers at all. I think you need to turn off your iPod and pay attention. I think a heck of a lot of people have said that.
I didn't interrupt, I didn't shoot you down on stuff like that. I'm here to ask a question. I got what my board members did.
Let's
They
do
voted on
this
it.
questions, and here, just ask something. Do you have anything else to say?
Okay, and then it's such a big federal funded ordeal and state funded ordeal. Why don't they move it to the Adirondack Park where the state could benefit from it? Then nobody here would have to worry about having arguments between each other and family members and community people. I mean, you guys know, everybody knows that this went right straight through our community and separated everybody. I mean, we can't even sit and talk to our neighbors anymore because you don't know if they're for it or against it. I think it's a big family feud going on as our town, and we don't have a very big town as it is. But thank you for answering that.
I'm Tony on the road. One question is to go back to the survey that we talked about weeks ago. I didn't know to address the lawyer on the survey point. Basically, just to see who wants who for it, who's against it. I didn't know if he addressed you on. He said he was gonna, or how did you talk about it?
There's not going to be a survey based on my legal advice. It is illegal in New York to make land use decisions or other local law decisions based on generalized public surveys. This is not like California where you can do referendums. You can put an idea up and have a referendum. New York law does not allow that for any type of land use decision. You elect leaders to a board. If you don't like their decisions, then you change them at the ballot box. But New York does not allow towns to spend money on surveys, nor does it allow towns to make decisions based on generalized public approval or opposition. It requires towns to create records of evidence and make their determinations based on those records of evidence.
Well, the only other thing I really have to say is that based on these companies coming in and buying up and wanting to put their windmills in, I would be concerned basically on how these windmills or how your contracts are going to wind up at the end because of Verizon. What is it, Verizon now? Horizon changing from Zilka. I mean, your contract, and you got to really keep close eye on it because they're changing and selling out day to day. How do you know for a fact that when these windmills are up and after they're going, if they're actually going to be locked into what they're saying? Because they're going to be sold to another company or sold to somebody else that may not even abide by what we're trying to promote tonight.
Yeah, and the answer to that is a legal principle known as money talks and BS walks, which means that they have to put the money up under this draft law to decommission those facilities before they can build them. And that money is not subject to their bankruptcy, their transfers, or anything else. It's something that the town can go against if the facilities are abandoned or are not operating. And the answer to that is to make sure that those funds are in place to do what the decommissioning at the beginning. And I don't know, that's what this ordinance suggests. And they're talking to this board, that's absolutely what they've told to me they want.
So if, say for instance, the windmills go through, they sell out to a different corporation, which they've already done a couple different times. Is what we write today going to stand with them different companies buying them out? Going to set forth the same principle of what we're trying to put in together today?
The answer under this ordinance is yes, and if you look at the ordinance and you think there's ways of strengthening it, it's by all means suggested, but there's two ways. First is the fund is separate from the company. Whatever the fund is, or a surety or a bond, isn't dependent on who the company is. That's why I say bankruptcy doesn't affect the decommissioning fund. Secondly, there's a provision in the law that says you can't transfer the facilities without the permission of the town, and the permission will be granted as long as the new person, A, agrees to meet all the obligations, and B, proves that it can.
All right, thank you.
Just one quick question again. Have we determined the numbers yet? Thank you. Number on the turbines.
My name is Greg Ryan. I live in Churubusco on the Route 189. I just wanted to remind Mr. Spitzer that you are being paid by the town of Clinton, not by the town board, but by the people, and that you need not insult us.
Yes.
I'm Cindy LeClaire, and I live on the Campbell Road in Churubusco. And at this time, I'd like to have my attorney, Clark Jackalone, speak for me.
My name is Arthur Giacalone. I'm an attorney from East Aurora, New York, which is close to where Mr. Spitzer is from. My first thing I want to say is I'm not thrilled that somehow this changed from a public hearing to an informational meeting, because frankly, my clients would not have spent the money to bring me here for an informational meeting. We thought it was going to be the one formal chance to respond to a proposal, and that's why I'm here today. And as Dan knows, on very short notice, because I spoke with him Monday morning on a different matter, and I had no idea I would be here this evening. And I prepared very quickly and came here very quickly. And so that little glitch has cost my clients a substantial amount of money, and I just think it's regrettable that you would issue a public notice, say it's a public hearing, and then at the last minute switch it. I think it's really problematic. You know, there are a number of fundamental questions that I'm hearing from people that I don't think are truly being answered right now. One question that I have is, if we're having an informational meeting, why has this town board started at the point of this proposed ordinance allowing wind farms, rather than starting either neutrally or with the resolution to exclude wind farms? Somehow or other, that decision was made without major public input. This board has the power to exclude wind farms from the town of Clinton. That is a viable option, and it's something that should be considered. I am not going to sit here and spend a huge amount of time going through that proposed ordinance step by step, because this isn't a public hearing, and because it gives more credibility to that ordinance as the starting point. So when you hired Mr. Spitzer, who certainly knows the law very well, you already started this town on a course of action to allow windmills rather than to exclude them. I find that, and my clients find that, very problematic. Number two.
Well, one of the biggest criticisms of what we had at the very beginning was, we don't know enough about this. So our first thing was to go out and get an expert. So we had contacted other towns and to try to find an expert on this, because we're a small town. We don't have the capabilities of going out through and finding out all who experts are and so forth. So I contacted and they gave me Dan Spitzer's name. He was. They said that he was an expert in the wind field. He's going to go either way that the town board wants. If we decide to go against the windmills, we'll turn it. We'll definitely go against the windmills. We're open-minded right now. We've had made statements in the past that I'm for wind power. I don't have a problem with wind power, but I am willing to listen to anybody. And if I find that the people are against it, or anything what's wrong with the wind companies, or I don't approve of it, or I find out new things in these meetings, I'm definitely willing to go against the windmill companies. The same as every one of these board members. We have an open mind. I don't know where people think that we're closed-minded. This thing right here, we would have never fit this meeting in the town of Churubusco. That was why we went to Ellenburg. We made this out of good faith to come to Ellenburg. We're taking this just as much credit out of this meeting as if it would have been a public hearing. We're trying to do as much credit on this as possible. We don't plan on adopting it in the next board meeting. We plan on listening to everybody, trying to address everybody's complaints. addressing a lot of situations where we wasn't capable of knowing for ourselves.
Well, Mr. Supervisor, thank you for that response. In all due respect, you could have hired Mr. Spitzer to write a law that excluded wind farms. You chose not to, and that's my point.
And you're absolutely right. The first question I asked them, Art, and I get paid the same amount no matter what the law says, is do you want me to write a licensing law or do you want me to write a ban law? And obviously, as he said, at this point they wanted a licensing law. But we're just at the beginning, so give your best reason why you think it should be a ban law.
It's a strange starting point, that's all I'm saying. Number two, Dane, you could smirk about that, but the bottom line is you're already giving credence to having them rather than not having them, rather than having a neutral position in an information meeting neutrally, having people talk about both sides. And that's not, and your starting point is that law. My second...
Hey, I respectfully disagree with you, Art. I'd much rather, if they're thinking about having a wind licensing ordinance, and they absolutely owe it to the public to have things like setbacks and other issues out there from the beginning, and not have that, and have as many ideas and many issues as possible at the meeting. Now, everybody thought that this was going to be a public hearing until I learned that this was not in the town of Clinton. I'm sorry, I don't have the map of the state memorized in terms of where the school was. But in terms of having the issues out there, I have to respectfully disagree with you and say that to the extent that their first decision was to consider a licensing ordinance, then absolutely they did the right thing with putting a proposed ordinance out there, because that gives the public the chance to comment on as many issues as possible.
And I think the residents of the town have the right to have the town board starting at the position that we don't have them now and we don't want them, and go from there, and that's not what happened. Let me move on. I'm not here to argue with you, Dan. Number two, I'm interested in how these setback requirements were arrived at. The town supervisor said we had other numbers, and quote, we got back to reality, close quote. Now, I'm not sure what that means, and I also don't know which of the comments that Mr. Spitzer, you got back from the wind farm proponents that you accepted, and how your draft changed, if any, after you had comments with the wind farm people. But the bottom line is that the setbacks that you arrived at in this draft are less protective than many communities.
It's a fair question. The answer is that I got my setback information solely from the town, and to the extent that they had any comments about setbacks, they may have made it to the town, but frankly, I didn't take any advice or suggestions from the wind companies about setbacks. That only came solely from the board. I mean, I sat down and basically went over each setback with the board and said, this is, what do you want this to be? And they had done a survey, and that's my understanding where they got their numbers from, but there's no, in terms of the input as to the form of the law that these gentlemen have given us comments on, the setbacks come solely from the town.
And again, the public doesn't know what information the town board had as they made that very significant decision on what point to start at with the setbacks. Let me get to my other points. I don't want to be here for an hour. I'm sure no one else wants me to be here for an hour. Dan, you mentioned earlier that right now, because there's no zoning law in place, that the floodgates were open as far as wind farms. But the bottom line is, and I think you'll agree with me on this, if any wind farm applicant was getting financial assistance or subsidies from the state or from the local IDAs, they would have to go through the secret process and a whole process before they ever could construct a wind turbine in the town of Clinton.
That's correct, but the town of Clinton would have no part in that process because it has no approvals.
I agree with you, but you just in case anyone has the impression that a wind turbine could be built tomorrow, because this town doesn't have an existing law right now, that impression I don't think is accurate, because there's a lot of other things that have to be done elsewhere by other decision makers other than this town.
To the extent that they had not previously gotten the other approvals they needed, you're absolutely correct. If they had all the other approvals and all they needed was a building permit, then they could come in tomorrow. To the extent that they didn't comply with whoever they needed approvals from. However, if they were building a wind tower without in a non-wetland area, so the DEC would be involved. If they weren't getting an IDA pilot, so the IDA is not involved, it was strictly a private venture, they can come in tomorrow.
But Dan, you and I know that what will be proposed is going to cover several towns and be more than 1 or 2 towers. And so again, I want the public to understand that the floodgates is not a realistic image to have, because nothing could be built right now. This town, if it wanted to, could adopt a moratorium and could look at enacting a zoning ordinance or some other local law and make sure that they don't have wind farms, if that's an option that they were seriously looking at, and that hasn't happened today.
And so you would agree then that doing something is better than doing nothing?
Correct.
Whether it's a moratorium or a ban or ordinance, doing something is better than nothing.
But doing something and starting at the proposed ordinance is assuming that there's going to be wind towers, rather than either be neutral or assuming that there won't be wind towers. And Dan, you haven't mentioned it, but this local law can't be approved without first complying with secret.
Well, yes, I did. I mentioned that in my opening comment.
Now, you mentioned that an applicant.
No, I specifically said, when I laid out the time frame for what the town was going to do, that at their November meeting, they would be considering whether or not to do a net deck or a pos deck on the local law before they got that. If I did, I apologize, but absolutely, the local law itself is an action subject to secret.
And what the town board needs to understand, and the residents need to understand, that under secret, there's a very low threshold for when a positive declaration needs to be adopted that requires a draft environmental impact statement that will look closely at all areas of potential environmental harm, look at all mitigation measures, and look at reasonable alternatives such as no wind farms. And so I urge this town board to, if it continues down the line with this proposal, to adopt a positive declaration and conduct a full environmental impact study so that you know ahead of time what sort of potential harm this town could have coming toward it, as far as the environment, which includes the character of this community, and it includes public health, before you adopt an ordinance that would allow them literally any place but the village and this community.
And I think you ought to expand on that, Art, because so people understand what you would do in that case is actually prepare what's known as a generic draft environmental impact statement that look at the potential impacts that could happen if the law,
Correct.
if the board decided to do a positive declaration.
Correct.
And that would be separate from any kind of environmental impact statement that might be required from under the application. However, if a generic draft environmental impact statement was done and the impacts of the actual towers were less than that generic draft environmental impact statement, a supplemental study may not be required.
Only if there were specific standards in the generic DES, yes. But let's not bore everybody with this kind of technicality. I'm trying not to.
Nevertheless, I think that this is a difficult process, and I think this is a community that really hasn't been through secret too often. And I think we have an obligation to educate people to the extent they don't.
I want to respond to a couple of comments that were made by the wind farm representatives. The gentleman from Noble got up here and said no one will experience greater than 50 decibels from their proposal wind farm, which they can't tell us where the location is. What's flawed about that comment is, as Dr. Pierpont pointed out, 50 decibel is not an appropriate or adequate starting point for this community. And what I would urge this board to do, if it insists that it is going to allow wind farms in this community, is have a ordinance that says that you cannot have a wind turbine that creates greater than a 5 decibel increase in ambient noise levels. Measured at the property line, since as far as I know, the folks who bought their property here and pay taxes here haven't done that just to stay in their house with the doors and windows shut, but want to be able to be on their property. And so what I would urge is a standard that says that no wind turbine can have more than a 5 decibel increase over the ambient level as measured to the closest non-participating property line. The representative from Noble also suggested that there would be no property value impacts of wind turbines. And I'm just trying to think of, after 55 years of being on this earth, how these 400-foot industrial machines would not impact nearby residential properties. He claims that he's read other studies. Well, I've read them too, and the studies that are out there are deeply flawed. The studies that are out there that you will find on wind farm websites, believe me, have an agenda behind them, and it's to get wind farms developed. I want to point to, and I will provide to the town board this evening, a copy of a study that was done, a report done by the town of Lincoln, Illinois zoning officer, someone without an axe to grind, without profit to make. And that report indicates, and let me back up a little bit, they built 33 towers in 1999. We don't know how many these folks want to do, but there was 33 towers in Lincoln, Illinois. That zoning officer's report indicates that homes, residential property within 1 mile decreased 26% in value. Properties within the view shed, properties that were greater than 1 mile away, but could still see within the view shed of these wind turbines, decreased 18% in value. If this town is going to insist on a law allowing wind turbines, there should be a provision in there that would require reimbursement by the applicant of lost property values for anyone whose values went down because of the wind turbines. I also will provide you a study that was done by the licensed surveyors in England. As you know, they've had wind farms in England for many years, in which 60% of the licensed surveyors responded saying that they experienced adverse impacts on residential property values for any property within view of wind turbines. Well, you just did. I'm almost done.
I interrupted him, so we've given a lot of people what
I'm just going to make one last comment, and I appreciate how boring it could be listening to me. One last comment. Dan, you indicated that towns can't spend money on surveys to determine what the town feels like. I'd like to tweak that comment. I would agree that towns cannot spend money for an informal referendum, but towns across the state frequently spend money on surveys as part of their comprehensive plan process. They do it all the time. They ask questions of their residents and property owners, and they decide what the priorities are and what the interests and concerns are of their community. That would be an appropriate vehicle for this town board to get a feeling of what the residents feel about something that would change for generations the landscape in this community if you went forward and allowed wind farm development in this community. Thank you for your patience.
Let's remember he was paid to say that.
Just to finish up, Mr. Giacalone is absolutely correct. If the option that the town took was to put a moratorium in place and do a comprehensive plan and put in zoning before it made any decision on wind towers, then as part of a comprehensive planning process, a survey could be done of the priority town. So I'll accept his tweet, if you will. You can't do a direct referendum, but you could do that first.
I did identify themselves in that way before they made their comments, because that specifically colors their comments and they're not objective.
Ma'am, I can tell you that I'm getting paid to be here, but whether anybody else wants to do that, frankly, I think is their business.
37 years ago, when I hung my first load of wash out on the line, my vision was to build a windmill when I retired here in this community. And I'm so surprised that the other people in this room with these huge companies had that same vision. And I am 2 years from retirement. And I am not personally gaining anything unless I do sign. I haven't signed anything yet. I am definitely looking at an option. I think this is an unbelievable opportunity for this community. I respect the board for taking the time to listen to people, and I think that the lawyer who's just spoke is under the misconception that the people in Churubusco don't want this. And I have been going to meetings for over a year and a half now. There's been a lot of open discussion, open door. There's no secrets. And I think accusing these people of trying to, meet quietly with a lawyer or making decisions without proper information, we've been very, very informed. And I think this process is an example of it. I respect the fact that it's people in their moved up to this area and don't want to look at a windmill. But if I want to build a windmill, that's my property. And so you're going to take my right away to live on my property. Then what's going to happen? We're going to start having ordinances we can't hunt on our property. We're going to have ordinances that we can't farm certain things on our property. It's just the beginning.
Richard Harriman, Route 189, just north of town, on a mile. Comments on what I came through the other day. It says the wind turbine companies, Noble and Horizon, are not utility companies, but investment companies for J.P. Morgan and Gold. Well, my understanding is that the New York State Public Service Commission required all utility companies like NYSEG and Niagara Mohawk to sell their power generation equipment and divest themselves of that. So therefore, we don't know who owns any of those generation companies, those generation facilities. It's my understanding also that it's either NYSEG or Niagara Mohawk is British owned, not US, British. That's what I thought it was, but I didn't want to. Yes. British owned.
It's a company called National Grid.
Yes, that's what I've heard. So we don't know who owns what. These companies, they're here to produce power. It's a private company just like those are. It's also stated that they're a value of approximately 1.6 million, and upon operation, basically, there'll be some government monies coming back to them. I say good for them. If they're going to spend $75 to $80 million of their money to invest in this area, and they get something back from the government for doing it, I know if I was going to put something in my property and the government was going to pay me back some money part of it, I'd be glad to take that check. It's also been stated that they're here because we have no zoning. Well, that's probably true to a point, but zonings can have variances. We have the wind. We also have one major asset, and that's high power lines, which my feeling is that because we have those high power lines, we open ourselves up to any energy producing company that wants to come our way, because they don't have to run miles and miles and miles of lines to get to the high power lines. That means oil, coal, natural gas, even nuclear is all possible. Some people here may have heard, some of them may not have heard. This school system right here is getting ready to embark upon a power generation heating plant of about 1.6 million roughly. And they will be using oil, and it'll be a smokestack. It'll have emissions. We know the directions that the wind blows here. Ellenberg Depot is going to get the most of those emissions. We'll get some. Maybe if we had some decent cheap power, or they were available to have decent power, they could go another route. But it's going to be a smokestack. It's going to be there. We're going to see it. Talking about seeing it, I was over towards New England a few weeks ago, and I looked over the skyline, and here's this, I don't know what you would call it. It's supposed to be a tree sticking way up above the skyline. Personally, I would have rather seen the cellular tower, which it was masking, because this thing looks so out of place. It's ungodly. And I mean, it's stuck up a long ways above the tree line. I think we need the power. I believe we need the power. We need it produced locally, so it can be used locally. I know there's been comments that it wouldn't be used locally, but, you know, it's easiest to keep it here and not ship it downstate. And, you know, I think I'm concerned about the financial aspects of it, as far as it being good or bad, either way. They're quiet. I've been out to Fenner. I don't have readings, but I stood on a porch by a windmill that was very close to that transformer facility, power substation, and I had absolutely no problem at all listening to what little sound it made. And inside the trailer, there was nobody home there, so I couldn't talk to them. But inside the trailer, they wouldn't have heard it at all. Windows open or not, it just, you know, was so quiet. You know, there was a few many problems that was obvious, but, you know, I don't see anything noise-wise. I think the 1,000-foot setback is reasonable. They're 500 feet out there. That's way too close. I have to agree with that. They're way too close together. They sit on a ridge, so you can see them for miles. Yes, we've got some valley area, you know, and you would see them as you come up the valley, but, you know, basically we're kind of flat. And a lot of farmland, a lot of forested area. So that's all I got to say. Thank you.
Okay, at this time, I'd like to have, because we're going to start wrapping it up, I'd like the new people, anybody else that haven't talked, I'd like to give everybody the opportunity to speak. No. Okay, I'll let this man right here do it first, because he's been after me for a little bit, and then I'll let you do it. Yeah, John, I'll let you do a quick one, and then
I'd just like to reiterate the lawyer that was up here speaking. The board has to take in consideration to ensure the property owner of the home that they will not lose their value of their home, and they must be compensated for loss of value of their homes. Because you can't take something from us that we work so hard for, and most of the people's savings, as this man over here said, went into his home, and you just can't take that from the man because he worked all his life for that. So you have to respect that of the taxpayer citizen. And if you don't, you're not doing the respect to the people that you're expected to respect them for.
My name is Jim Securi. I own St. Lawrence Valley Dairy on County Line Road. And I just wanted to address the issue that I think wind power is a significant positive process, positive energy source. Everything I've read in all the farm publications I take, they say that harvesting the wind is one of the newest and most, and potentially one of the best new cash crops for farmers and dairy. And I think that, I just want to tell the board that I think that they have a reasonable ordinance that they've drafted. I think it well protects neighbors. And importantly, it also allows farmers, dairymen, landowners in Clinton Township to participate in growing this cash crop that, yes, we could benefit from, and it would help us. And I would encourage you to adopt an ordinance that's reasonable, and as long as all laws are complied with, the farmers and landowners of this area can get the advantage of that situation as farmers and landowners in many other parts of the country are getting the advantage.
My name is Bill Puport. I live on 189 Churubusco, and Monday, myself and 3 other residents of Churubusco went to Fenner, and it was a rainy day, and the wind was blowing. We figured probably 15, 20 miles an hour. and we got within 300 feet of one of these turbines, and the noise was very, very low. It was very little, and they were running, the guy said, full capacity. And I mean, the noise for machines that size, I couldn't believe it, and I was thinking I was going to look at an ugly machine. There's me like a state of an art and very streamlined. I was very, very surprised. I wish other people could go, excuse me, and hear them also, you know, because they're not noisy. Thank you.
Can we make some closing comments on our side?
If I let you do a closing comment, I have to make sure that you let everybody do it. Is it quick? Yeah. Okay.
Yes, I'll make it brief. There was just a couple things we wanted to point out, that most of the people that were up here in favor of these are not in favor of wind power. They have contract signs that are filed at the Clinton County Courthouse. Anybody can go see them. Okay. Dr. Nina Pierpont presented her evidence of a 1.5-mile setback from houses. There are other scientific studies that are recent that also back this up. The other facts and the things that we have, the government incentives and all the money that they get, the taxpayer dollars that actually pay for these things. Since we were not informed of what kind of meeting this really was, we don't have the documents with us, but if anybody wants to contact us, we do have government documents, scientific studies, journal articles, and we are glad to give them to anybody who wants them. So please don't be afraid to ask, no matter what your opinion is, so you can become educated and make a more informed decision. Thank you.
Just like to thank the board and of course all of you for giving us the opportunity to be here and answer the questions. Clearly there's a strong desire for folks to have information. We are building this year, 3 hours from here, down Route 11, we're building a 200 megawatt wind farm, 120 turbines. As part of the secret process, we had to go through do significant studies on the potential impacts of the wind farm. And so I just, just so you guys know, at the level of studies that we go through, these are this is the impact statement for the Flat Rock wind power project. So as part of the secret, we do have to go through very, very significant studies, of this magnitude. If anyone would like to go to the Flat Rock wind farm, we will take a bus tour of folks down there on October 30th. Just come and see me or any of my colleagues, and we will take you down there. It'll be on a first come, first served basis. Also, of course, if anybody wants to go down there, they are welcome to go down there. I think we just have to respect private property. And just lastly, I'd like to point out a couple of my colleagues, if you have any questions. They are Josh McGee, Greg Camus, Colin Fleming, Charlie Felinsky, and Todd Hopper from New York Wind Power, with whom we're partnering, and also Doug Ward, who is our attorney. So if you have any questions, if you'd like to go to a wind farm, just contact any of us. If this process goes forward, we will be studying everything that it is correct to study. So I thank you for your time. Yeah, the maps here are just showing the windy areas in the towns of Clinton and Upper, and also the what's farmland, what isn't farmland, and so on.
Okay, again, thank you all for coming, whatever your view is, and thank you to the town for getting this organised. I've got three things very quickly to say, and I guess this is as much to the town management and the attorney as it is to the people that are here. We came here to offer a potential benefit to this town. And, anything that we do here is for the purpose of creating mutually beneficial relationships with the town and with the people who live in the town. We strongly believe that responsible siting and protection in law is the cornerstone of a successful project here, and we will subscribe to any reasonable legal process that ensures that the town people are comfortable with what it is that we decide to do here. And finally, never forget that any decision that the town board makes is going to be in the context of a specific application, not on some general notion of a wind power plant. All of the information will be available to make an informed decision. And our commitment is to do all of the work necessary to make a fully informed decision. Thank you.
Okay, meeting is adjourned. Thank you very much for coming.